All right, I
Are
just
you-
started
never are.
recording.
Okay. Are you in the office on a regular basis? I'm going to try to take this call here. This is the Ohio Elections Commission. Full report.
Hey, Chris, is there, you know how like sometimes with banking you can do an electronic signature? Is that, I don't know how easily that's loaded or not loaded or what's the process, but maybe that would be something if this is going to continue going forward remotely. Maybe that would be easier for you guys if we could, you know, do electronic signatures.
Now, and I apologize, my computer was frozen there, so I missed a good majority of what you said. I heard about electronic signatures, but that was about it.
Yeah, I just didn't know like what the, you know, what all that would entail, that if we were continuing to be remote for any length of time, maybe it would be something that, you know what I mean? If we could all do
To look
electronic
into.
signatures, it would save you know, save money and time.
Well, that's a
So-
possibility. That's something we talked to Phil, and I can look into seeing how we could do that. Just, yeah, to have a signature on hand as opposed to having to continue mail them out and, or do our driving around to get everyone to do that.
Right. I mean,
yeah,
I'm not
I'll-
trying to
I'll
make more
ask
work
them.
for you. I'm actually trying to save you some work, but I don't know what all that
And
entails.
see, because I'm all for it. Well, I don't think it would be that difficult. I really don't. I think it would just be a phone call for our IT guy up on the 19th floor and say, hey, how would we go about this? And
Yeah.
he's pretty good with that. So I am all for it.
Yeah.
What are you all for?
Hold on a sec. Bear with me. I'm writing down
Okay.
E-signatures.
16.
Oh.
While we're working remotely, or doing all this remotely, to see if for minutes they could do electronic signatures. That way, it's just passed around to an electronic signature for each of them and it's done.
Yeah, okay. That makes sense too. Obviously, I'm not on the technological cutting edge.
I'm not either, but I just know there's been a couple things I've done like that, and I thought, oh, that maybe that would be handy instead of trying to make you
Yeah.
guys run all over creation.
Well, what do you think, Phil?
We're waiting for Ms. Tavares,
Oh, okay.
and she said she would, she said she was going to join us. I don't know.
There she is.
Go. Look at that. You asked Mr. Gromer, the chairman asks, and people just magically appear. What power and authority you have.
Yeah.
Wow. Look at that. Good morning, Ms. Tavares.
Good morning. I'm having problems with my computer, so I'm on my little phone.
Oh, okay. Well,
Are you
whatever it
back from
takes,
Mexico?
we're glad to have you.
It's good to be here.
Well, I said to you and just to Christine as well, and I had almost anytime I send an email to you or Christine, to the health email to
Primary
your
one,
business,
yeah.
it comes back to me as your company thinks I'm spam.
Nope. Yeah, but I get it. I get yours at Primary One Health and I get it on my private email. They're coming, but it might be bouncing back to you.
Yeah, it's every time I send it to you guys, it says it's that you Primary One thinks I'm spam, which I don't have a problem with that at one level. I mean, makes perfect sense to me.
Okay.
Morning, Mr. Klinger. How are you?
Good, how are you?
I'm good. I'm good. I would think that we'll be taking care of you relatively quickly if you're only around for the one case.
Yep.
Let me start making notes here. Oh, Hannah is in the lobby. Okay. Well, Mr. Chairman, I think anytime you're ready to start, we can probably start.
Okay, I would like to call the October 1st, 2020 meeting of the Ohio Election Commission to order. At this time, I'd like to ask Director Richter to take the roll.
Okay, Ms. Kaufman,
Here.
Ms. Cunningham,
Present?
Ms. Taveras, Vice Chairman Kreitz,
Here.
Chair Bromer.
Here.
Those are all the members present. We have been previously informed that Mr. Norman has a conflict in court, and Mr. Beatty had a personal issue arise. So 5 members are present. That is enough to make up a quorum. And so we can begin business today, Mr. Chair.
Mr. Chair,
Should,
Mr.
Yes.
Chair, may I make a motion to excuse those 2 individuals?
Second?
there's a motion made and properly second to excuse the 2 commissioners who previously informed us they would not be present. All those in favor of that motion?
Aye.
Aye.
All those opposed? The ayes have it.
Thank you.
Mr. Richter.
Yes.
Mr. Chair and Mr. Richter, could we have you tell us about the number of votes required to act when we've got 5 present, please?
The statutes still require there to be a majority of the commission. And so in order to take an action, it is still required that 4 members of the commission agree on any particular item. If not, then it would just be continued to a subsequent meeting. But that does not change, even though we don't have a full contingent available.
I guess before I turn this over to you, Phil, we should address the September 17th, 2020 minutes. I know we were all provided a copy. Are there any corrections from anyone? Hearing none, is there a motion?
Move to approve.
There was a motion.
I think,
I'm sorry, Phil, go ahead.
was that Ms. Tavares that seconded?
Correct.
Yeah, okay, thank you. Okay, then the motion is to approve the minutes is properly on the floor. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
Thank you. That motion passes 5-0. And starting to work through the agenda, the first item that I have on the working agenda, at least, is item number 4 in the actual agenda. Hatcher versus Antani. It's a complaint that asserts that the respondent failed to list a particular campaign contribution in a report. We do not have certified mail service on the respondent in that case. Mr. Klinger is actually here on the complainant's behalf. I told him yesterday that I anticipated that we would continue this matter. I checked the USPS website as well. They attempted service on August 7th and have not done anything with it since, including returning it to us. So we will send out subsequent regular mail notice here in short order. But my recommendation would be that this matter be continued because we don't have service on the respondent.
I make a motion to continue. Cunningham.
Second.
A second by Ms. Kaufman. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
5 hands in here, 5 yeas. That motion passes 5-0. Derek, you're done if you want to go. Oh, by the way, everybody, in talking to Mr. Klinger, I'm going to pass along some private information for him. I'm contemplating setting the Bellbrook case for November 17th, November 19th. Thank you, Chris. And Mr. Klinger indicated that he may not be available then because his wife is pregnant and due right around that time. So
That's cool.
I just thought I would embarrass him appropriately. So,
Thank you.
not a problem. See you, Derek.
Bye. Take care, everyone.
The
Take
next
care.
item on the agenda that I have on the working agenda, meeting agenda is item number 1, Stevens versus Hairston. It's a complaint involving a failure to include a conspicuous disclaimer on the campaign literature. No response has been received, but we do have certified mail service. Oh no, actually certified mail service was returned, but we sent regular mail service on August 24th. So that is appropriate for us to assume that service has been made on the respondent. It's a little distinctive. It's a little interesting case, obviously, because the materials that were provided and for which the complaint was made assert that that the disclaimer is not conspicuous. I think it's a negative mail piece against the complainant. And I have to agree with her that this would be a different kind of finding for the commission. It's next to impossible to find the disclaimer for that piece of literature on there. I mean, it is hidden well within one of the pictures in very light print. And so taking the complaint at its word, taking the statute as it is phrased, the fact that there's no response in the matter. I have listed my recommendation to find a violation and impose a fine of $200. You can see on the working agenda that Mr. Hairston has a bit of a history with the commission. That certainly played into the recommendation that I have made, but treating it a little differently because of what the disclaimer statute allows us to impose fines for. That's where I kind of came up with $200. I'll be glad to answer any other questions you may have, or commission can move forward on this or do something different, but that's my recommendation.
Mr. Chairman. Mr. Chair, I have a question. On the previous cases, did we ever get a response from the complainant?
Nope. No, we have not.
Thank you.
Although, you can tell from the most recent case, which we just dealt with, I think it was in our August meeting. No, that would be July. It was our July meeting. The report was filed that was at issue there. The Cuyahoga County Board of Elections reported, but no response was submitted as related there. So those are all outstanding matters, essentially.
I would like to make a motion that we concur with the executive director's recommendation and find a violation and impose a fine of $200.
Cunningham, second.
Thank you very much. That motion is properly before the commission. Is there any other discussion? If not, all in favor signify by saying aye, raising your hand.
Aye.
Aye.
All opposed? That motion passes unanimously. Thank you very much. The next item on the working agenda on page 2 is Hicks versus Ubel. This is a disclaimer complaint as well out of Claremont County. It too is a little bit different and interesting than what we normally deal with. Mr. Hicks is available online there. Counsel for Mr. Ubel is present here. Chris is going to step aside and let him use his computer, I think, so that he would be able to address the commission as well. The issue here is that I guess you'd say a false disclaimer was placed on the literature because materials were circulated that reflected that they were the responsibility of the Claremont County Republican Party. But after a lengthy investigation by the Claremont County Sheriff, filed with this commission that that wasn't the party that was circulating these materials, but was circulated by a particular candidate, Mr. Ubel. The investigation by the sheriff's office was conducted that confirmed that. There are also matters pending I believe in Claremont County Common Police Court as it relates to this, or that will be pending as it relates to this. We're really only dealing with the disclaimer issue. Certainly, we can hear from Mr. Hicks. We can hear from counsel from Mr. Hubel as well. You can see my recommendation is to find the violation and impose a fine of $100. But Mr. Chair, if you want to hear from the parties to the matter, we have the ability to do so, or you can proceed forward.
I think since the parties are here, let's hear from them.
Okay. Mr. Hicks, it would be your basis to go first. You're the complainant. You're muted, Mr. Hicks. We can't hear you.
Okay, can you hear me now?
Yes.
Yeah.
Okay, Mr. Richter, I think you did a nice summary, but effectively what happened here is Mr. Hubel represented that he had the authority of the Republican Party to a printer to print materials that were slate cards that were to help him. A backstory on the whole thing is one of the reasons why
I'm going to stop you there, Mr. Hicks, real quickly, just because I should have sworn you in to make a statement.
Okay.
And I didn't do so. I apologize. So, Mr. Hicks, we're going to do the whole truth and nothing but the truth to help you out.
Yes.
Okay. Thank you very much. Now, please make your statement. I apologize for interrupting you.
No worries, no worries. So I apologize for being on mute before. So what happened in this is Mr. Hubel represented himself to a printer as having the authority of the Republican Party to send out materials that were favorable to him. The reason why, one of the backstory's motivations for that is that he was on probation at the time for a prior criminal conviction relating to tampering with a petition, where he had been, so he was getting hammered on that issue because he was on probation while running for the Senate. So he was then charged, as Mr. Richter mentioned, after an investigation with falsification and obstruction. And those charges just recently were dismissed only because the matter got moved to a special prosecutor versus an in-house cooking thing in Claremont County. And I believe that it'll be imminent that felony charges may be filed against Mr. Hubel at some point. I think I heard that, I know your authority of what you do as a commission is limited in scope and doesn't involve all the things I just brought. But when I just heard $200 as a fine for a disclaimer, and I just heard Mr. Richter say $100 fine for something like this, I think whatever the maximum penalty you can have is what should be being considered here. And I think it would be outrageous otherwise when there's criminal activity involved in falsified mailers that are taking place. So I don't know if I take questions, but that is effectively my statement. But again, I think that it would be irresponsible on part of the commission not to basically throw the book at this one when it involves criminal matters that are pending or will shortly be pending.
Are there any questions of Mr. Hicks from commission members?
Phil, try that again. You were garbled.
Oh, sorry. I kind of leaned away. I was just saying, are there any questions for Mr. Hicks? If not, you can hear counsel Mr. Hubel. Please go ahead.
Thank you. Thank you for the opportunity to address this board. Mr. Hubel would have been here personally present. He had sent some correspondence. He has had a scheduled trip to Idaho, and he is in Idaho and wanted to make sure the board, the committee knew how important this was for him. And I am here to represent Mr. Hubel. My name is Aaron Moss. And what I completely disagree with Mr. Hicks' representation is that this was an unauthorized act. In part of your correspondence, Mr. Greg Simpson, the chairman of the Claremont County Republican Party, submitted in anticipation of this hearing a letter to this body. And Mr. Hubel was represented by Mr. Hicks as not authorized. Our endorsement policy in Claremont County Republican Party allows an endorsed candidate, which Mr. Hubel was, an endorsed candidate from Claremont County Republican Party, to the resources of the party. The slate card that is the subject of Mr. Hicks representing that he has somehow fraudulently used it is incorrect. The slate card that Mr. Hubel had contracted for the reproduction of the slate card for him to send out was an endorsed slate card that was true in form as it was created by the Claremont County Republican Party. The Claremont County Republican Party, after they go through an endorsement meeting, creates a sample ballot. I refer to as a slate card sample ballot. The act here is that Mr. Ubel reproduced the slate card and anticipation of mailing it, and it would have came from the Claremont County Republican Party, even though Mr. Ubel was the person bearing the cost of the reproduction and distribution of an otherwise approved slate card. So my question is, when 3517 does include the print, distribution, reproduction, distribution, all must have the who paid for disclaimer. This particular slate card did have the paid for by Claremont County Republican Party. Chairman Greg Simpson, I believe that was also provided by Mr. Hicks in your materials. So the materials did have a disclaimer, but it was Mr. Ubel who was actually sending it out. The other matters that are sensational and inflammatory about an unrelated part petition Board of Elections issue makes this more sensational than it really is. It's, you know, and by the way, that Mr. Hicks, I have no knowledge, and I don't know what knowledge Mr. Hicks has about some anticipated short order new felonies coming, but that unrelated charge, or that, well, this charge with falsification unrelated to 351720, there's some other issues Mr. Ubel's facing. But as we stand right now, that is a Nolly case. That is a 2020 CRB 01270 out of the Claremont County Municipal Court, and the special prosecutor out of the AG's office that nollied that case was Mr. Joel King. That was not an in-county prosecutor decision to nolly that case. I think Mr. Hicks used a home cooked or something reference to that. That's inaccurate. This was already an AG that put that nolly on in 2020 CRB 01270. And I really think that's peripheral to these hearings. The only notice that we have is 351720. So those aren't at issue for this committee, but I just wanted to comment on them since Mr. Hicks brought that up in a way to make it sound like he has some knowledge that Mr. Ubel is going to be indicted tomorrow or something. I have no information that if that happens, it happens, but all I can tell you right now is that it's nollied as we stand here today. So what I think you have is an authorized act for Mr. Ubel to use the sample ballot as an endorsed candidate, and he was reproducing and sending it an otherwise approved sample ballot. We're asking the committee to make a no finding.
Thank you, Mr. Moss. Are there any questions from the commission? Whoa, hold on. I am muted now. Yeah, come on. There we go. Are there any questions of the commission members, Mr. Moss?
Yeah, I have one. I'd like to know why in some of the material, or in the material we were provided, there was a copy of a letter from Mr. Greg Simpson, who was the chairman of the Republican Party in Claremont County. And he stated he filed a complaint that someone sent out cards with his name on it, which they did not send, which they, I guess they mean the Claremont Republican Party. Is that true?
Well, we got what I can speak to is I had 2 or 3 conversations with Mr. Simpson, as I recall, when this was all developing I can't remember whether it was February or March. But anyway, I had conversations with Mr. Simpson. I had more than 3 conversations with personnel from the sheriff's office as this was all ongoing about this matter, about who was responsible for these materials. And I more or less just kind of talked about what our role is, filing a petition, the application 351720, and those kinds of issues. And if you would to read some of the materials, I think the Sheriff's Office, after I talked to them about our role and how we participate in the system, I believe, in reading some of those materials, they reflected to Mr. Simpson, wanted to file a complaint. It's appropriate to bring to the commission to do that. We never received a complaint from Mr. Simpson related to these circumstances. Like I said, although I talked to him on numerous occasions, subsequently we did receive this complaint from Mr. Hicks, which raised these issues. We received a response from Mr. Ubel, which you were circulated. We also received that letter from Mr. Simpson. I presume he felt obligated, or he felt it necessary to submit that letter on behalf, I guess you'd say on behalf of Mr. Ubel, because Mr. Ubel was a candidate, an endorsed candidate for the Republican Party, and he explained the circumstances from his perspective as chairman of the Republican Party. As it was a part of our file, I circulated it to all of you for you to take however you wished to take it. So that's how we came into possession of that letter. That's how it was circulated to you, along with the complaint and the response in this case. I don't know that I've got a whole lot else I can add aside from that, but that's why you got those materials, and that's what came from. Mr. Chair, members, do you want to hear a comment from Mr. Hicks?
Sure.
Okay.
Can you hear me again? I didn't mute myself.
Yes.
So just in quick response to Mr. Moss, I guess you guys could continue this case and we could see what happens with other charges. But the fact that Mr. Ubel was on probation was his motivation in trying to create pieces that appeared to be that he had support from other places. So by doing this with these cards, Mr. Moss already admitted it was Ubel that paid for the cards, but the disclaimer said that the party did. Mr. Simpson's actually the one that filed the complaint with the sheriff's office, but in a way that was meant home cooking, that created a situation where they didn't think they would ever figure out who did it. When the sheriff's detective actually figured out who did it, then suddenly Mr. Simpson wouldn't file the affidavit that the sheriff's office asked him to, and came to me because I had been a witness in that with the sheriff's office to get me to file the affidavit that you guys received, because Mr. Simpson refused to do so to protect Ubel after the fact. If there's any question relating to any of this, or if there's an option for you guys to continue it and see what happens with charges and other things, then I would recommend that you do that rather than make any decision now based on what I think is spurious information being provided by Mr. Moss as to what's actually gone on here.
May I comment?
Please, go ahead.
Well, first, the representation, the party bore the expense of the original creation of that sample ballot. That sample ballot was created after the endorsement meeting. Mr. Ubel reproduced it at his own cost. He did not bear the original cost of creating that political literature. That was a Claremont County Republican Party cost. What spurious comments I'm making, I would like to know, because I think that I'm accurate. Do you disagree? I mean, not my opportunity to cross-examine Mr. Hicks, but do you disagree that the party paid for the original production of that material? If I could direct a question, Mr. Hicks.
I don't think that's appropriate.
Okay, I apologize.
I think that we lost Ms. Tavares. I don't know if.
Yeah, but I think
I'm back.
Oh, she's back.
Yeah.
I was trying to get on my computer. It didn't work.
Okay.
Let me just pose for thought a question. If Mr. Ubel wasn't a candidate and he was John Smith in his living room, received some campaign literature, and he really likes that candidate, and at his own cost, he reproduces literature that says at the bottom, paid for by candidate, make up a name, candidate Smith. and he reproduces at that citizen's cost. Is that a distinguishing feature for us to consider? And this electronic day and age, if my Claremont GOP puts on the website a sample ballot, and I take the sample ballot, download it in the PDF, and reproduce it. Now that sample ballot's going to say at the bottom, paid for by the Claremont County Republican Party. I'm reproducing that at my own cost. Is that a 35-17-20 violation? Because after all the sensationalism surrounding this, collateral matters to Dave Ubel, at the fundamental basis of what I believe this committee is considering is the reproduction of a sample ballot that has paid for by Claremont County Republican Party. And in this particular case, it's being reproduced by a candidate, David Ubel.
Who was not a private citizen, was a candidate for office that is has to do campaign finance filings and so forth involved with this. So these just ridiculous arguments. If you guys can do it, I would just continue it and let the special prosecutor only recently became involved in this because it was being handled in-house in Claremont County. And you can hear from Mr. Moss the way things kind of work in Claremont County, where it's these ridiculous explanations. He reproduced something and he paid for it, but what if he was a private individual versus a candidate? Just continue it and let the special prosecutor do his work. The notion of Mr. Moss saying the special prosecutor dismissed the case as a nully, Mr. Moss knows the reason the special prosecutor did that is he wants to get the charges right because the in-house charges in Claremont County were rigged to protect Mr. Ubel. So just continue the matter and let it play out a little bit so these cases that Mr. Moss are making can be borne out by what actually happens in the next month or so.
Gentlemen, hold on. I appreciate what you're talking about, what's going on as it relates to a criminal matter that may or may not be pending, etc. The commission members are welcome to disagree with me, but that is not relevant to, at least to me, that's not relevant to the case that we have before us that relates to these materials and the circumstances surrounding these materials. What the special prosecutor may do is up to the special prosecutor. While it certainly may involve these materials, it isn't an application of 35-17-20. That's the responsibility of this commission. And so, if the commission would like to hear any further, certainly they would be welcome to step in and say, yes, I'd like to hear further. But at this point, I think we've heard enough about that matter.
I agree, Phil. I think we've heard enough also. I just want to recap this. I think the issue before the commission is whether or not the disclaimer on this piece of information was proper or improper. And that's what's before us. I don't think there's any dispute in the fact that Mr. Ubel was the endorsed candidate by the Claremont Republican Party. However, there's also no dispute that he put this piece of literature out on his own without the knowledge of the Claremont Republican Party. And therefore, I think your recommendation, Phil, of finding a violation occurred and assessing a $100 fine is appropriate. And I would ask the commission members, do you have any other comments to be made on this case?
And Mr. Chairman, this is Commissioner Kreitz. Hey, Phil, I've got a question for you. How did you arrive at the $100 fine?
This is the first time that Mr. Ubel has been before this commission. There is a disclaimer on the materials. It's my belief that Mr. Ubel's disclaimer should be on there as well, because it is he who paid for the circulation of these materials. And so while I appreciate Mr. Nixon, I appreciate what Mr. Moss is saying, taking all the circumstances in the case under consideration as it relates to what this commission does. And again, looking at if there, as we have been discussing over the recent meetings, we'll discuss in future meetings, the commission's longstanding rule was for someone before the commission for the first time, violation of good cause, especially for a case like this, and a case really of first impression in terms of disclaimer present, but yet not who's responsible for the exact circumstances of this particular mailing. a good cause would have been at least in the ballpark previously. But as I assessed all the circumstances in this case, my belief we had with all of what occurred here in terms of party not being aware of the circulation, I don't know if I want to say attempted cover up, but at least the situation where not everybody was willing to be straightforward in terms of, who was responsible for these materials. The fact that the person that actually paid for the reproduction and circulation of these materials didn't put his disclaimer on it. As I took all those factors into consideration, I thought that a fine was appropriate, but yet because it's the first time before this commission, and that we have the ability to only impose, a maximum fine of $500 is nothing to shake a stick at. But I felt $100 was appropriate. The commission, after hearing all the complainant and the counsel for the respondent, and after hearing my recommendation, wants to go in a different direction, I'm certainly not going to throw a lot of arguments in terms of what should happen or whether I think it's appropriate. I made my recommendation based on all the facts and circumstances that are present here, and what I believe is an appropriate penalty for what I view as a violation of the statute.
Any other comments from commission members? Hearing none, is there a motion?
Mr. Chair, I do have one more follow-up question. I apologize.
Okay.
Phil, a question for you is, I understand what we have to determine here is whether or not there's been a violation of Chapter 3517. The question I have is, what, if any, weight can be given to the fact that there's a sheriff's department, a sheriff's office report that's been attached to the affidavit that would suggest that there has been, I want to emphasize that there's been some deceit involved in this process. Is that something that we can give weight to? And if so, is that a reason to go ahead and delay this for a full hearing so we have an opportunity to consider that?
I certainly considered it as I went about making my recommendation. Yes, that along with all the various telephone calls in which I was involved as this matter was going forward, and my understanding of the facts and circumstances. So yeah, certainly I would not necessarily discourage taking that information into consideration. As it relates to continuing it, if that's what the commission wants to do and having a more full and complete hearing, again, those are the decisions that you all make. I merely make recommendations as it relates to what should happen. But considering the complaint, the response, the sheriff's report that we have before us, we could certainly continue it. I'm not, in my mind, I believe that there's sufficient evidence before us right at the moment to assert that there has been a violation of the statute. I'm not certain in my mind what additional information would be gleaned by continuing the matter and having a more full hearing at a later date. Certainly could do that. Like I said, you guys make the decisions as to what should be done under any circumstances. But as I view all the materials and circumstances here, I believe there's been a violation. There should be a penalty of some sort imposed. I don't believe that, to me, I don't believe that continuing this matter will aid in any way the situation. On the criminal side of this, I believe that it will go forward on the Title 29 violations, separate and distinct from whatever is done here. And I don't know that the 3517, the finding of a 3517 violation and imposition of a fine would impact what happens on the criminal side. That's my.
Any other commission members have any comments? Hearing none, is there a motion?
This is Charlita. I would move the recommendation of the executive director.
Is there a second? I second it.
Thank you. We have a motion and second to properly place this before the commission. I am to through a roll call just in case there is some sort of breakout here. And so each person will be asked individually. You either raise your hand or say aye if you would, please. Ms. Kaufman?
Before you do that, Phil, would you restate what your suggestion is that we're voting on?
My recommendation is that the commission find a violation of Revised Code Section 3517-21, which obligates a person responsible for materials to put their disclaimer on it. I think I said a violation, and impose a fine of $100 in that particular case. Ms. Kaufman?
Aye.
Ms. Cunningham?
Aye.
Mr. Kreitz?
Aye.
Ms. Tavares?
Aye.
Chair Broom?
Aye.
That motion passes unanimously. Thank you very much.
Thank you.
Okay. The next matter for the commission is one of the more interesting matters that I've seen come before the commission in a while. Item number 3 on the agenda, case number 2020G-014, Jordan v. Fry. It's a complaint alleging various campaign finance related violations of the chairman, or I'm sorry, not the chairman, of the sheriff of the Shelby County. Just yesterday, we received a response. I have circulated that to you. I circulated it to you late yesterday. Presumably you had a chance to review it. Honestly, my synopsis doesn't really synopsize the response that much. It just kind of goes over what was generally included therein. You can see my recommendation, which was originally to find a violation, impose a $1,000 fine based on the complaint only. Then I got the response, and this may be one case where the response almost made it worse for the respondent than if he hadn't said anything, because as you can see, if you look at it, the campaign finance report that he included with his response has negative balances in it, which you can't have. And it's for a pre-primary filing. I then talked to the Shelby County Board of Elections and inquired of them as it relates to what information they had in their files as it relates to this campaign committee, to which a quick response would be not much. They did not have a copy of a designation of treasurer. As the response reflects, on December 13th, which would be a general filing date for a post general, which they wouldn't have necessarily been obligated to file, he only filed 31Bs, which are statements of expenditures of campaign finance reports. There was no cover sheet involved. There was no summation. That's all that was provided. Subsequently, they did provide reports. In talking to the board, they did indicate that they got a post-primary, and I'll give them credit for at least matching up one amount. The beginning balance of the post-primary was the same as the ending balance of the pre-primary, but of course that balance was a minus $2,091.56, which again, can't have. And what they indicated to me, I don't have a copy of the actual post that the Shelby County has, but I will get that if we need it. As of the time of the post-primary, the amount that they reflected as an ending balance was a negative $10,428. in his response, again, you can see that he talks about sending things to the Secretary of State's office, which I talked to Brian Katz at the Secretary of State, and I see his BK as one of the attendees right at the moment. And they did receive some information from him and at least tried to send it to the board to a particular email address that they have, but it doesn't appear that the board ever opened it based on my conversation with the board that said they didn't have like the designation of treasurer, which was signed, by the way, in September, but supposedly submitted to the secretary's office in December. Why the 3-month delay? Couldn't even begin to tell you. And so, and then the manner in which he dealt with the cash contributions, the one that he talked about in terms of the $250 from 3 different guys, bizarre, admittedly, but okay. You got a, if you look at the response, he got an explanation from the guy who was there. They were submitting monies, and there were 3 of them that went together. A little shaky, a little interesting, but what the heck? I'll give him credit for that one. But the $300, it's one of those minor, well, depending on how you look at it, minor details. The $300 cash contribution that he says, oh, we took care of that. We gave him the money back, and then he gave us a check, which that's generally a reasonable way of dealing with that situation. Except if you look at the pre-primary report, what he ended up doing was amending the pre-primary report to reflect that it was still all done on January 31, whereas he included documents that show the refund being made on April 22nd and a check then being given back in the same amount on April 22nd. So that leads me back to my recommendation of, I'm not sure whether to stick with my $1,000 fine recommendation, double it to try and get a message across, or to say, maybe we need to have a full hearing on this thing and give them an opportunity to come and understand some of the problems that they have. And I'm going to interject here real quickly. He may not want to speak, but I'm going to ask, because Brian was going to look into whether they had some other information that, according to this, had been submitted to the secretary's office. Brian Katz, did you have anything further you wanted to add as it relates to, whether there was more information that you guys may have had in your office relating to this case or not?
I do not right now. Thank you, though.
Okay, not a problem. There you go. All right. So no further information. So I don't know. I'll take your comments. We can discuss this further. I'm a bit confused. I'm also a bit concerned at the status of all these various reports that are not very good reports, for want of a better phrase.
Mr. Chairman, I have a question.
Go ahead.
To the executive director, is this a first-time candidate?
I don't know that specifically, but I think the answer to that is yes. I think he was recently appointed, and the guy that filed the complaint against him appears to be his opponent. At least as you look at the complaint form at the very top where it kind of lays out the basics, complainant, respondent, it says a committee to elect Jordan Sheriff, and the complaint is Mark R. Jordan. I believe that to be the case, but I honestly don't know that, Ms. Taveras, sorry.
And then a follow-up question. The reports that he submitted to the Secretary of State's office, has he ever filed any reports with the Board of Elections of his county prior to submitting these reports to the Secretary of State?
According to the board, and I didn't get the date on which it was submitted. Yeah, I did, I think. I think a post-primary election report was filed on May 27 of 2020. That again, like I said, it reflected negative balances, both beginning and ending. I don't have a copy of that report. That's the only report that the Shelby County Board has in file from my conversation with the lady at the Shelby County Board. They do not have a copy of the DOT. They did not have a copy of the pre-primary report, which is what is included with the response, because I asked them about that. And again, they have, what she indicated to me was that the post-primary report is the only report that they currently have in file.
I was just trying to determine why did it go to the Secretary of State versus the Board of Elections?
And I also throw in, I don't know the answer to that because that's obviously not where they should have gone. And you know, we had this complaint. You know, I'm doing my preparation work for it, you know, I think on Tuesday. And when I went into the office yesterday and got the mail, you know, here's this response now that I have available to me. And so that was my first opportunity to look at the response. It's dated September 25th, so it was only like last Friday that it would have been prepared anyway. You know, after it, he even says, I haven't received your letter dated August 4th. You know, and so his response just says, oh yeah, we sent it to the Secretary of State's office. It's like, well, you're sending it to the wrong office there, buddy. I'm not sure how else to help him at this point. The other fascinating thing is, if you look at the DOT, again, fascinating. I'm not sure whether it's right, wrong, or indifferent. It reflects a treasurer of somebody named Zimmerman, William Zimmerman, and a deputy treasurer of Maria Larger. Well, the candidate signed it, and the deputy treasurer has signed it, but we don't see any. And the reports were all submitted by Maria Larger, who's the deputy treasurer. Who knows why Mr. Zimmerman's even on there, because I'm not seeing his name appear in any filings or anything else. But again, that's just kind of one of those little side notes.
Phil, has there been a request to have a full hearing on this?
Not really, no. I mean, the complainant just kind of submitted his complaint and says, hey, here are things, various things that I see as potential violations. You know, like it talked about Fryer for Sheriff campaign literature and signing the state Bill Zimmerman Jr. as treasurer. Well, he is, presumably, but the complainant wouldn't have known that because he didn't see a DOT because it was filed with the wrong office. And so I don't want to say that that's not necessarily a violation, because the DOT wasn't properly filed with the right office, but they did list the proper treasurer, kind of. You know, and some of the other things, he had explanations in his response. You know, it does say, I mean, there are many more errors and inconsistencies, many of which can be verified due to extremely poor financial accounting and reporting. No surprise there. This committee should be fully audited. Don't disagree with you there. Specifically, that's kind of not our responsibility. But again, if we wanted to set this thing for a full hearing, we could kind of do that. I mean, I could certainly, I don't know if I want to say try and help in that regard, but at least try and point him in the right direction. And so that's where, toward the end of the day yesterday, as I was working through my recommendations, and I said, well, you know, I'm not going to change what I originally recommended because the response wasn't really that helpful in the grand scheme of things. But in the back of my mind, I'm almost thinking, this guy needs some help. Or his treasurer needs help, or both of them need help. I don't know.
Phil, can you remind us what our standard to apply is on a preliminary, in making a determination on a preliminary review?
if we believe that there is sufficient evidence of a violation between the complaint and any submitted materials to the commission, we have the ability to make a finding by the preponderance of the evidence. It's just kind of a 51-49 standard. Don't need to have clear and convincing evidence or anything like that. And so, it's obvious that there are, to me, it's obvious there are violations. Failure to properly file a designation of treasurer, failure to file complete and accurate campaign finance reports, the improper handling of the cash contribution, and he lists in the complaint the failure to the donor list of over $25 at a fundraiser. Well, that may or may not be an actual issue. We could request that he submit his listing, which he is supposed to maintain. My gut tells me it hasn't been maintained, and so if we were to request that he wouldn't be able to provide it. That's just my gut feeling. So I mean, it's apparent that there are violations, but also, the reports are just wrong. You can't have negative balances in campaign finance reports. But at the same point, that would lead you to believe that there's incomplete filings, which you could also presumably impose a per diem fine amount until they're properly reflected.
Mr. Chairman.
Yes. Can't hear you.
All of a sudden, Mike,
You're
we
muted.
can't hear you. I'm not sure why.
You have muted.
What, can you hear me now?
Yes.
There you go.
Oh, okay. Would it be helpful in your opinion to have a hearing? And if so, how would it be helpful? In my own mind, I'm trying to decide. There seem to be a number of issues here, some of which maybe we can resolve, some of which I don't think we can resolve. And I would be interested in your opinion as someone that's been doing this for a long time, whether you think it would be helpful to the resolution of this matter to have it set for a full hearing.
What my gut says is that the basis, the reason to have a full hearing would really, to me at least, would really be for the benefit of the respondent, his campaign committee, and his treasurer. Because otherwise, I think a $1,000 fine would get their attention. I would think, but I'm not sure where else they get good information on how to go about correcting some of their problems. And that's my reason for saying maybe we do a hearing on this as an effort to try and help the respondent and his treasurer out. Because this is like campaign finance 101 violations that they have here. Filing with the secretary's office when you're a local county candidate, submitting only expenditure reports without a cover sheet, in the post-gen period, which maybe it could be, we don't, at one level, we don't know, could be they did something during during the general election period for which they needed to reflect activity, although, based on the reports that we have or don't know the answer to that. But, at least they should have filed well, it gets confusing as to whether they should have filed an annual or just a pre-primary because of the early primary this year. But they presumably should have filed an annual because they were, well, we can assume they were created in 2019 because that's when the DOT is signed, but was it really submitted? It's just there are a variety of, for want of a better term, interesting issues as it relates to this. And that's the only reason why I think maybe we set it for a hearing, is in an effort to try and help the respondent. Because, based on what has been presented to us, there are violations of the statute that are direct and straightforward, are really admitted by the respondent because of the nature of the response that's been submitted. And we could just impose a fine. But The only reason I would think a hearing is to try and help the respondent. That's it.
I guess I think you hit the nail on the head. As you read all this information, I think I count at least six violations. And
At least.
yeah, and you're supposing that they would welcome a hearing to get better educated. I'm not so sure, unless they ask for it, that that's going to bear any fruit. Frankly, then what do we do in that hearing? Do we still find that a violation occurred? It seems to me we have to. And we then end up imposing a fine. I mean, we're at the same stage we are now.
Mr. Chair.
Good point. I'm sorry, go ahead.
From my perspective, it sort of boils down to this. Does the commission want to impose a fine with the hope that this individual files the reports and straightens it out? Normally, if somebody didn't answer, what we would do is impose a per diem fine to encourage people to get straightened out, get their reports filed, and then would reconsider the matter. We could certainly do that for some of the reports in this case, although typically we don't do that in a preliminary review. To me, just because of the lack of reports being filed, and even though there are apparent violations, the combination of the two makes me lean towards setting it for hearing. And if the candidate or if the respondent chooses not to appear, I think that puts us in a different position in terms of how we might handle fines than it would maybe today. So my inclination is, and I'm going to move that the matter be set for full hearing for the board to fully hear from the respondent if they choose to come. And if they don't, then we'll be in no different position than we are today and maybe can more fully evaluate it. So that's my motion.
I would second that, Mr. Chair.
There's a motion made and properly seconded to move this issue to a full hearing. All those in favor of that motion?
Aye.
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 Aye. All those opposed? The ayes have it.
Now I will pose then a question based on that. Do we try and ram this thing on the 29th prior to the election? Obviously, we got an election coming up. It kind of involves this, or subsequent. I'll take opinions.
My opinion would be to set it at the soonest available date.
I concur.
As the move, particularly as the movement in the second, we will get notice out of here either today or tomorrow that this matter is being set for hearing on October 29th. So thank you very much. And I appreciate your patience with me on this one. Like I said, this was one of the more, better phrase, bizarre and interesting cases that I've been involved in.
We didn't vote. We just did a move and second on that one.
Well, no, everybody, he called for a vote, and there was a vote to set the matter for hearing, and it went 5-0. I said,
okay. Okay.
Yeah, there was, and then I subsequently asked about date to set it for, and I was looking for general guidance. I'm normally going and setting dates for hearings, etc. So,
right.
And I just said I will set that for the 29th, and we'll get notice out of here as quickly as we can to try and get them lined up. It will be interesting to see what kind of responses I get back from the respondent on that one.
Well, they'll have their opportunity.
Yeah, exactly. All right. Well, I think we're off to the groups at this point. And so I think we can move forward. And, at the bottom of page 4, there's where the groups start. So, Mr. Chairman, if you want to take those on.
All right. Starting with number 52, the following two cases, 2020R-286, 2020R-298, have been withdrawn by the Board of Elections.
And that's all we needed to do was acknowledge it, and you've done so. Thank you.
All right. In the following case, the executive, and that case is 2020 R-240. The executive director recommends that we reconsider case number 2019 R-098, consolidate the cases, dismiss the consolidated cases, and declare the committee terminated. And again, that's in case 2020 R-240. Is there a motion?
So moved.
Second.
And Ms. Kaufman and Mr. Kreitz. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
Unanimously. Thank you very much.
The next case is 2020 R-241. The executive director recommends that this case be dismissed. The committee was declared terminated at the commission meeting of October 31st, 2019. Is there a motion?
Move we follow the recommendation of the executive director.
Cunningham, second.
Thank you. All in favor signify by saying aye or raising your hand.
Aye.
Motion passes unanimously.
The following cases, the executive director found a violation, but for good cause imposed no fine, and those cases are 2020 R-245, 2020 R-250, 2020 R-259, 2020 R-261, 2020 R-270, 2020 R-285, 2020 R-288, 2020 R-295, 2020 R-303. Is there a motion?
Motion by Cunningham to follow the executive director's recommendation, find a violation, but for good cause, not impose a fine or penalty.
Seconded by Kreitz.
Thank you. All in favor signify by saying aye, raising your hand.
Aye.
Aye.
Next.
Okay, the following cases, the executive director has recommended that a violation be found and that a $50 fine be imposed. And those cases are 2020 R-247, 2020 R-289, 2020 R-290, 2020 R-297, and 2020 R-302. Is there a motion?
I move the recommendation of the executive director.
Second.
Thank you. All in favor signify by saying aye or raising your hand.
Aye.
Passes unanimously. Thank you.
In the following cases, the executive director recommends a violation be found and that a $100 fine be imposed. Those cases are 2020 R-251, 2020 R-253, 2020 R-284, 2020 R-291, 2020 R-293, 2020 R-294, and 2020 R-296. Is there a motion? I make the motion. We concur with the executive director's recommendation.
Second by
Second.
Cunningham.
I think Ms. Cunningham got there first. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
Thank you very much.
In the following case, the executive director recommends that we reconsider case number 2020 R-301. I'm sorry. In case number 2020 R-301, the executive director recommends that we reconsider case number 2018 R-319, vacate the previous finding, consolidate with this case, find a violation, and impose a fine of $100. Is there a motion?
So moved.
I second it.
Thank you, Mr. Bromer. I'm taking you as the first person I heard. All in favor signify by saying aye or raising your hand.
Aye.
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 Thank you very much.
In case number 2020R-268, the executive director finds that a violation occurred and is imposing a $150 fine. Is there a motion?
I move to follow the executive director's recommendation.
Thank you, Ms. Kaufman.
Second.
Second.
Mr. Kreitz, thank you. All in favor signify by saying aye or raising your hand.
Aye.
Thank you very much.
In case number 2020R-260, the executive director is recommending that a violation be found and that a $200 fine be imposed. Is there a motion?
This is Tavares. I recommend we follow the recommendation of the executive director. I move that we follow the recommendation of the executive director.
Thank you.
Second by Cunningham.
Thank you. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
Very much.
In case number 2020R-252, the executive director is recommending that a violation be found and that a $300 fine be imposed. Is there a motion?
Mr. Chair,
I
I
make the
move that we
motion.
follow the recommendation.
Okay.
That's
Thank you, Mr. Kreitz.
Second.
Second by Chair Bromer. All in favor signify by saying aye or raising your hand.
Aye.
aye.
Motion passes unanimously.
In case number 2020R-256, the executive director is recommending that a violation be found and that a $1,000 fine be imposed.
That's a matter which I received this morning, an email that contained a letter from the respondent in this case. And it's also just for the history of the case, if you go to my updated ICWs, which I sent out yesterday, it is case number 2020R. I was right there and I lost it.
256.
Thank you. 256. You could, I mean, my $1,000 fine recommendation. I'm trying to open up. I thought I had that item opened, and then when I went to look at it, it wasn't there anymore. So I'm reopening that letter. Hopefully it'll open here soon. But you can see that Mr. McBee has a rather lengthy history before the commission. It doesn't look like I think he did pay that one fine if you go back to a consolidated 2011 R194, 10, 98, etc. It doesn't reflect it there, but I think that was paid. But you know, I mean, he has in his response, you know, that he submitted his reports. I originally got the reports from the staff at the Cuyahoga County Board of Elections, you know, where they were glad to see him get this all taken care of and terminated, which he is now. This matter is terminated. But if you look at his response, you know, he raises, it's a rather lengthy one, talks about some of his history, how he thought all this was filed, only later came to find out that it wasn't. You know, from his response, I think you can even say, and I know from talking to the staff at the Cuyahoga County Board, that they essentially did a lot of the reporting for him to get him updated, brought back into compliance, and terminated. All he had to do was sign the reports, which he eventually got around to doing. So it is now terminated. He makes comments about the financial difficulties under which he is currently operating. in various other circumstances. I kept my recommendation the same at $1,000. Obviously, one, because of the nature of the history of all of the various violations that he has out there, and considering what he's facing in terms of getting contact from the AG's office for them trying to collect various outstanding matters, it's a heck of a lot better to do that for us to do this than it is for him to try and pay up to $85,000. I think it was included in there. But I also see, his concerns about financial difficulties and what COVID has brought on, et cetera. And so I just thought we could discuss it as we just kind of have. At least I've discussed it with you guys. I'll take any other comments and, whether you approve my recommendation as it is or go in a different direction, I'm good with it either way.
Phil, so the record will show that he's had prior violations. That's apparent. What are his outstanding fines at this point?
The best that I would think I rely on his letter, I think, which reflects, was it $85,000? Or, total balance, I see in his letter, $300,000, which if you add all of the various findings that we made, apply interest to it, which I know the Attorney General's office does. Oh, there you go. I received correspondence showing a total balance of $85,661.12. For all of the various reports that he has not made through the years, but that he recently made and has brought himself into compliance and terminated. So that would appear to be the outstanding amount that he is facing if we don't take this under, take this matter and make a subsequent finding as it relates to this matter.
So are you changing your recommendation, Phil? I wasn't sure at the end of that.
No.
Okay.
No, I'm not changing. I thought about it, but I decided, no, I'm going to leave it at this. We can discuss it. I think based on all the various outstanding priors, is it harsh? Yes. I will say that it's harsh, but it's not like he had just one case outstanding and he didn't come into compliance one or two times. I mean, we're talking about, a period of almost 10 years where, we've made a variety of findings where we're either getting, and I could go back and look at the priors, we're either getting certified mail service or more likely we send out certified mail service and then send out subsequent mail. And those notices are getting through. The board is sending notices on annual reports that are due. So it's not like he's totally uninformed about what should have been filed, for his, what was an open campaign committee.
Yeah. Mr. Chairman, I move that we follow the recommendation of the executive director.
Cunningham seconds.
Okay, we have a motion and a second to find a violation and impose $1,000 fine. At this point, I'd say all in favor signify by saying aye or raising your hand.
Aye.
There are any no votes, which I don't see, but vote the opposite, but that was unanimous approval of that. Thank you.
In the following cases, and they are 2020R-262, 2020R-266, 2020R-275, the executive director has recommended that a violation be found and that a $25 a day penalty be imposed with a reconsideration option. Is there a motion?
You were kind of muffled there, Ms. Taveras, but I saw a motion.
Second.
Thank you, Ms. Kaufman. There's a motion and second to approve that recommendation. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
Thank you.
In case number 2020R-282, the executive director is recommending that case be consolidated with case number 2019R-517, find a violation and impose a fine of $25 a day with reconsideration option. Is there a motion?
So moved.
I second it.
Motion and second before the commission. All in favor signify by saying aye or raising your hand.
Aye.
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 Passes. Thank you very much. Next
In
item.
case, go ahead.
No, go ahead. I just said next item.
Oh. In 2020R-267 and 2020R-283, the executive director recommends that a violation be found and impose a $25 a day with reconsideration option with payment of $250. Is there a motion?
So moved.
Second, Tavares.
Thank you, Ms. Taveras. A motion and a second before the commission. All in favor signify by saying aye or raising your hand.
Aye.
Passes unanimously. Thank you very much. We're off to the last page finally.
In 2020R-280, the executive director recommends to consolidate with case number 2019R-396, find a violation. Did I just do this one?
No.
No. Find a violation and impose a $25 a day with a reconsideration option with payment of $250.
Move we follow the executive director's recommendation.
Second. Phil, you're muted.
Still
You're still
muted.
muted.
Okay, let's try that one more time.
This is
I
being
don't
recorded
follow
too,
my
isn't
own
it?
rules very easily, do I? All in favor, signify by saying aye or raising your hand.
Aye.
Okay,
Thank you, Chris, because I was running low on power on my, and I muted that so I could say thanks without interrupting you guys. And then I must have hit the mute button twice because I thought I'd taken myself off mute. Anyway, go ahead, Mr. Chairman. We're off to 2020R-281.
In case number 2020R-281, the executive director is recommending that this case be consolidated with case number 2019R-514, find a violation and impose a fine of $25 a day with a reconsideration option with payment of $250. Is there a motion?
So moved.
Thank you, Ms. Kaufman.
Second.
Second by Mr. Kreitz. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
That passes unanimously. Next.
The following cases, 2020R-243, 2020R-249, 2020R-272, and 2020R-279. The executive director recommends a $6,050 fine plus $25 a day with reconsideration option. Is there a motion?
So moved.
Second.
That was Ms. Kaufman I heard first. Motion before the commission. All in favor signify by saying aye or raising your hand.
Aye.
The motion passes unanimously.
In case number 2020R-255, the executive director is recommending that case be consolidated with case number 2019R-147, a violation be found and impose a fine of $24,000 $200 plus $100 a day with reconsideration option. Is there a motion?
So moved.
Second.
Thank you, Mr. Kreitz. Mr. Bromer, there's a motion on the floor. All in favor signify by saying aye or raising your hand.
Aye.
Passes unanimously.
In cases 2020R-258, 2020R-265, 2020R-269, 2020R-271, the executive director is recommending a violation be found and a $24,200 fine plus $1,000 a day with reconsideration option. Is there a motion?
$100 per day, just.
I'm
to
sorry, what I say?
Okay, you said
1,000.
1,000.
Oh, $100 per day, excuse me. Is there a motion?
So moved. This is Charlita.
Thank you, Ms. Taveras.
Second.
Second.
Thank you, Ms. Kaufman. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
I've gotten pretty good at saying that. I'll give myself credit. Thank you very much. Mr. Chairman, we're off to the continued matters, which you had the ability to continue.
All right. The following cases are going to be continued for service, and they are 2020R-239, 2020R-242, 2020R-244, 2020R-246, 2020R-248, 2020R-254, 2020R-257, 2020R-263, 2020R-264, 2020R-273, 2020R-274, 2020R-276, 2020R-277, 2020R-278, 2020R-287, 2020R-292, and 2020R-299.
Thank you very much. All right. Kind of extra business here. I talked briefly, Mr. Bromer and Mr. Kreitz were on early, and they're generally aware of what I hope I'm about to talk to here, because all of a sudden my screen is acting up. At our August meeting, we had a grand total of 7 cases out of Adams County. And of those 7 cases, we continued 3 for service, and I recommended the imposition of a $100 fine in the other 4. And the basis for my recommendation was the fact that the reports were filed, but they were all filed in July. They were for failing to file the post-election report due at the end of, after the last year's general election, so December 13th, 2019. They were all filed in July. No response was submitted to the commission. We had green card service on all of the matters on which we acted. And after we sent out notice last week that we had imposed fines, I think every one of the persons to whom we had imposed a fine called the commission to ask for an explanation and an understanding of why the fine was imposed, which I gave them. And then in most cases, which I repeated to them at least 3 or 4 times throughout the remainder of the conversation, because they couldn't quite understand why a fine had been imposed. Even after I explained it to them repeatedly, hey, they did not timely file their report. They were referred. No response was given, which I could take into consideration to potentially make a different recommendation. Those were the circumstances. I recommended a fine. Well, not only did they repeatedly complain to me, and the reason why I say repeatedly is because those conversations, which should have lasted about as long as I've just talked, what, a minute, 2 minutes, generally ran from 5 to 10 minutes, as they kept questioning me about why. I don't understand why. How could this happen? The board told me everything was taken care of. Then they called the board, and I got an email from the board last week, and I said, hey, I recommended the imposition of a fine. They didn't file their reports. And the board has said, oh, well, maybe we want to withdraw those now. Because obviously all those folks were calling the board and complaining to the board. Adams, Ohio, SOS. Let me see what we got here. The board has said, we were told at the time they filed the reports that all they needed to do was file the report and then we would contact the commission, which they did. They told us that they had filed the reports. They're concluding their email to me, which previously had said, we have received campaign finance filings. Oh, no, that's I apologize for kind of mumbling through this. Yeah, they're just saying that they got everything. They questioned me as to why I did what I did. And, I said, yeah, you told us that they all filed. I understood that. I told them that the other parties have an opportunity to appeal our decision if that's what they really want to do. And that you made the decision based on my recommendation. Their statement back to me says both were told at the time they filed their reports with our office that all they needed to do was file the report and that we would contact the commission, let them know they had fulfilled the requirements. I don't believe they were instructed by our office to follow up and contact the commission. Any future filings we have, we'll be sure to let them know that they also need to contact you. Based on that information, I feel like we need to withdraw the complaints on these three and change our policy within our office. Okay, that's what they're telling me with their email that I got on Monday. And so I'm bringing it to you to see how you want to approach these matters. They all got certified mail service from us that not only say file your report, but also you have the opportunity to submit a response to the commission had they read that letter. But we do have the board coming back and saying, hey, maybe now we gave them wrong information or incomplete information. We'd like to withdraw the complaints. I'm presenting that to you, at one level. I make recommendations, you guys make the decisions. If you want to withdraw allow the board to withdraw these matters because they filed, okay, I don't have any problem with that. We've done that before when boards have subsequently come to us and made that kind of a request, even if it is after the fact. So it's not something that we haven't done previously. But I told them I would address it with you guys and see how you wanted to proceed. And so I have now done that. And let me know, let me know what you want to do.
I have a question.
No, go ahead, Natasha.
Okay, and I guess this is my first thought. Are they not filing things properly, or are they not going through the proper channels because that's what the election board has told them? So is that why?
My gut would be that they just missed the post general filing date. And then when they got the letter from us that said, hey, you've been referred, then they got back in touch with the board, because none of the reports, none of these folks that are now coming to us, because they're, well, no, one person did file in February as I look at it now. But
Phil, when did we make our decision? And when did they get notice?
When did they get notice?
When did we make the decision and when did they get notice?
We made the decision at our August meeting. And they would have gotten notice of it last Thursday or Friday, because we sent out disposition letters last Wednesday. So they would have been getting notice of our finding September 24th, 25th.
Did I hear you say previously that the county board acknowledged that the board gave them wrong advice?
Well, what it appears that the board says they said to these folks was, okay, yeah, we'll let the commission know that you filed your report. And I guess they must have said to them something akin to, you don't need to do anything else. Of the ones that we filed, it looks like one lady filed her report in February, just for informational purposes. But the other ones in which we made a decision, all filed either in July or August, after we had sent out notice to everybody of the August meeting. So that's kind of where that stands. The one person filed in February, the others filed after we sent out notice that they had been referred. And what the board said, let me open that email back up again.
I think 7 coming out of a county that size, though, seems kind of disproportionate, maybe.
Mm-hmm. I don't, smaller counties, you never know quite what you're getting. These were all small village mayors or council persons would be my guess. I look at the one that says Manchester Village Mayor. As these folks filed, what the board said back again is, both were told at the time they filed their reports with our office that all they needed to do was file the report, and we would contact the commission and let them know they had fulfilled the requirements, which the board did. They informed it, because we reach back to the board when they get referred for a late file or a failure to file. Have they filed? And they said they did. And they went on to say, I don't believe that they were instructed by our office to follow up and contract the commission, that our office would do that, which again, they did. They contacted us and let us know that the reports had been filed. But again, I'd go back to, these folks presumably received our letter, because we have certified mail green cards in the file that reflects generally filing on either July 6th or July 7th. And our letter goes through the whole process of, here's what you need to do. File, if you're referred for late filing or failure to file your report. You have the ability to either appear before the commission, you can submit a written response that's presumably properly notarized, and we have bolded and highlighted the nature of a very simple jurat for the notary public to use to say, here's what makes it an official statement for the commission. So that's kind of where
the county board is taking the heat for this. Apparently, that's what it sounds like. Are they taking the heat for all 7 cases? Are they saying in all 7 cases, they told them, don't worry about it, we'll send the information on to the commission?
I would say only in the 4 that we've decided, because 3 were continued and we didn't make a finding in those cases, because we didn't have service on those folks at the time of the meeting. So it was only on the 4 in which we have made a finding of a violation.
Hey, Phil, this is Mike. I've got a question. Maybe I misunderstood you, but did you say that previously the commission has gone ahead and adjudicated the issue, and then we've agreed to, upon request of the Board of Elections, to withdraw that decision?
Yes, we have done that in the past.
How recently and how many times? I mean, that seems pretty dangerous precedent.
I don't remember that ever happening, or that I would have ever agreed to that if it had and I knew it.
Well, you may not have necessarily recommended it, but we have. I don't recall how often. I know it was until I had for want of a better term, a lengthy conversation with the person at the Butler County Board of Elections. They were pretty good about, after somebody filed a report asking us to withdraw it, And not all of them had been decided by the commission, but some had. And so some of those were withdrawn, prior to us taking action. But then I had a conversation with them and said, hey, you're sending those to us. We're doing all the mailings and other stuff and administratively dealing with it. And then you're telling us to withdraw. I mean, if that's what you want to do, okay, that's fine. That's your choice. You and the board have an option to do that. The last time I would have I'd have to go back and look to see the last time that we had a situation where we'd gone through the whole process, made a finding, and then allowed it to withdraw. I don't remember that off the top of my head. I know we have done it, but not that often in the grand scheme of things. I'm sorry, I don't have a better answer for that. I'm sorry.
I think I'd also want to know, in those cases you're citing as precedent, where the fact wasn't the fact pattern the exact same? I mean, did the board in this case in those cases say, we told them don't worry about it, we'll handle it for you with the commission? I don't know. Do you know? Were they the same, right on point with these 7 cases, or 4 rather?
Honestly, I'm not recalling. It could be. I know some of them had come. I know we've done it at least a couple times with Cuyahoga, where after we made a finding, then they suddenly realized that something was filed. They recognize it, and then we go ahead and withdraw, allow them to withdraw because it had been timely filed. So I mean, I know that has occurred. The ones that come to mind are the Butler County matters, and that may have been the case, but I don't think so, because Butler was normally not the will respond on your behalf kind of circumstance. This one, I would say this is probably a bit different than the other matters that we have addressed in the past like this, where the board has presumably said to them, we'll contact.
Well, we already took action on these cases. Is there any need to take any other action today?
Not really, no. I mean, I would just say back to the board, sorry, had you said you wanted to withdraw at after they filed, I would have gladly withdrawn them, because I mean, we had 2 that we withdrew today. Now the circumstances were different there, in that I think those were both from Cuyahoga. Oh no, they were both from Butler County, where those were either duplicate referrals, or they found the report after they had referred somebody and they said, hey, we screwed up, please withdraw those. So we withdrew those. Those were the ones today. And that's, that happens every now and then. I mean, I know that there's a couple pending in Cuyahoga where they referred, after they've sent the referral down to us, they've already said to us, hey, hold back on those and don't, please, we'd like to withdraw those. You may not even see those, because if we catch it before it goes into our database, we just yank it and withdraw it, because everybody has the ability to withdraw a matter prior to us taking it up under consideration. Back to your initial question, though, no, we've made the decision and the finding. I would just get back to the board and say, I addressed the commission and they feel like they made a final determination in this matter, and, are not going to take it up any further. And I can at least tell them, and at least that way the board can say, oh, we're sorry, whatever, and they can do whatever they want with the candidates. And then, we're the bad guy, which is fine. We're a bad guy anyway under the set of circumstances.
Well, as far as I'm concerned, that's the appropriate course of action, Phil.
I would concur with that too.
Okay. Not a problem. That's what I will do. I will inform the board, and I can always go back and rely on the fact that, I appreciate what the board said and how they tried to help them out, but they got our letter. Our letter explains they should file a response with the commission. If they read the letter, they'd know that. Okay. Thank you very much. I appreciate your patience with me on that. I appreciate all your respective inputs as we go forward on that. I don't have any problem dealing with the board. But that was just one where now that everybody else is gone, as I said to Dennis and Mike before anybody else got online, I was really getting annoyed with everybody from Adams County that was coming back and repeatedly saying, how could you do this? How could you do this? And then I'd have to explain to them again why. Well, how could you do this? I told you already. Anyway, all right, I'm done with that. Thank you very much.
The other business on the agenda was the review of executive director, staff attorney. Prior to the start of the meeting, Phil and I and Mike discussed that, and I thought it might be proper to wait until we have the full commission present before we do that. I guess, what's the other thoughts of the commission members?
I agree.
Yeah, and I'm fine with that, and I thought that was the best approach as well. But it was something we discussed at the last meeting, and so I was bringing it forward. Okay. So anyway, I will resend the materials that I'd already sent to you prior to the next meeting in anticipation of that. But you obviously already got my memo outline and my vacation outline. Of course, I'll have to change my vacation outline to say I'm not anticipating taking off between October 17th and 25th, but I am taking, or 17th and 23rd, but I am gone between those days. Anyway, that's it. That's okay, Mr. Oh, that's right. Please go ahead. Mr. Hughes is here. You're muted, by the way, so you can, go. You do it. You've done more work than I have.
Hi, everyone.
Hello.
Hello.
I'm sure most of you are aware already. We're in the process of, I guess you could say, rejuvenating our website. And with that being said, last Friday, I submitted the email to our IOP team to go live with our new website. And they said it takes typically 2 to 3 weeks. Now, I don't know whether that 2 to 3 weeks is like when you order a pizza and they say 45 minutes and it shows up in 30, or whether 2 to 3 weeks literally means 2 to 3 weeks. So with that being said, being as we're kind of doing our final finishing touches and finishing that up, we wanted to run it past everyone to see and get your input as far as if we did a Teams meeting and went through each page, which all told, the meeting I wouldn't expect to take any more than a half hour at the longest, but just to run through it and get your feedback as far as what you may want to see either added or say, hey, this is unnecessary, or whatnot, and didn't know what availability you all may have in your schedule in the coming week to week and a half.
And I will add, when Chris and I discussed this on Monday, I guess it was, and we were going through everything, considering we've already canceled the meeting for October 15th, but had that on your schedule in some manner or form. Obviously, some of you may have subsequently gone and done something for that time. I was contemplating saying, why don't we just do October 15th at 10 o'clock as a way of us just kind of, we'll send out the Teams meeting. I'll do a better job of it this time and not include the wrong verbiage in the notice, even though it had the right date, obviously. But to just, go through the basic elements of the website on the 15th at 10 o'clock, unless you guys want to do it potentially earlier. Because, I mean, we could do it now, but then, Scott and Otto aren't around for that either. Because with the joy of this process here, and particularly with Chris on, we both have the ability to do it. He's just better at it than I am. He could bring up his screen and walk you through the website and what it will look like right now, for that matter. But we were thinking, just kind of use that 10:15 date at 10 a.m. To do that, go through it. Like I said, Chris said, take about a half an hour to go through all the various pages that are there while we've done some of the stuff that we've done. I think it will, in my own humble opinion, it'll be a lot better than what we have out there currently. You know, I mean, it's pretty basic still, because I'll admit to being the very basic sort that doesn't want to get into a lot of fancy stuff. But I think this will show a lot better, and we'll have better information and actually searchable information on it that wasn't necessarily there in the past.
All right, 2 questions, I guess. Will you be sending an email out to commission members to find out if that date and time are okay? I mean, since it's not a formal hearing, I guess we could play with the time. It doesn't necessarily have to be 10 or 10:15.
No. I just know that as he and I were discussing it on Monday, it was like, well, you know what? We got that time on, at least at one point we had on everybody's schedule. And so that's why I threw that out. But once we get done here, I can send an email around to everybody saying, here's my plan. I want to do it this way. Please respond back if that's okay, or if you want to do a different time.
Yeah.
And that way it'll give Scott and Otto a chance to chime in on, when and if they want to do it.
The second question is, can we see any of this before that date? Is that doable?
Unfortunately, the only way that would be possible is if I went through and I screenshot every single page, because there's we have a background of the page, which is where we do our work, and then we've got a front part of that. But the only way the front's accessible is if I log in under my username and share my screen for anybody to be able to see. If I were to send that link, it would try to make you log in to be able to get to it.
Forget I asked the question.
Yeah, and none of you at this point, there we go. At this point, the only 2 people that have ability to access this area of the state's website are Chris. So we're the only 2 that can get in, do updates, do all that kind of stuff, which we've already done to get it to this point where it's accessible. Were we to try and say, oh yeah, here, go ahead and do this, you would need to get in, create a login and a password at this particular website. It looks exactly like the ohio.gov website that you would try and access now, but it's, there's like 2 or 3 character difference in the in where you log in, and so it's slightly different. And it's one of those things I had a little bit of a challenge with initially getting on before I figured it out and figured out how to save the page. So
okay,
I don't know that it's worth it, to be honest with you.
So our next meeting is October the 29th. Does anybody have anything else? Hearing nothing, is there a motion to adjourn?
Yeah, but I have a question first. So are we going on the 15th? Are we getting back to you, or what's happening with that date? Sorry.
I will send out.
I was a little confused.
When I get back down to the office, I will send out an email to everybody saying our plan is to do a October 15th get together at 10 a.m. to look at the website, and to only look at the website. And you guys can all respond back if you think that's okay, or if you want to do a different time. At least that's my plan right now, based on what was said.
And then commission members, is everybody good with 10? Or I heard it sounded like some people wanted maybe later or a different time.
Well, Dennis kind of raised the issue of potentially doing
No,
it.
I just said, since it's not a formal commission hearing, we can play with the time. Hey, any time that day is good with me.
All right. And then I don't know, Phil, I assume since we're a state commission, we'll have to give public notice because it's a public meeting. So we'll have to follow the open meetings law on that to make sure that that's posted.
Yep.
And
well, or we could do this on 7 different occasions and do each one of you individually.
Nah, I'm not suggesting that. And if we're going to have a special meeting, whether or not, I just throw out there for the other members, do we want to talk about, just go over Phil's, if everybody's present, if we want to go over Phil's information at that time too, so we don't have to do it at the end of the meeting. I'm throwing it out there for all together. Don't really care, just throwing it out as an opportunity. That said, sorry, Ms. Kaufman, I interrupted your motion and I will stop talking.
So, wait, before we do this, so tentatively, we're going to meet on the 15th. And to your point, Catherine, I guess we have to make the public announcement that we're going to get together. Second to that, Catherine has suggested that we talk about your review at this meeting, which I think is proper, and I think we all concur with that. Makes sense.
Yeah.
And then our next formal meeting is October the 29th, right?
Correct.
Okay.
I think
So,
that's where we are.
I had
Yeah.
said, is there a motion to adjourn?
So moved.
Second.
Thank
I
you.
hear no one saying no, so this meeting is adjourned.
Take care,
Thank
all.
you.
Yeah, take
See
care.
you.
Thank you.
Thank you, everyone.
Charlene, I love your necklace.
Yes, I've been meaning to comment on that necklace all
I love
along.
it.
too. That is very cool.
Very cool.
I wear it every day. Encouraging.
Yeah,
Yeah.
makes sense.
Okay, bye. Have a good one.
Thank
Take
you.
care. everybody.
Bye-bye.